I'm seeing a lot of awesome people on here. I'm so glad that people are joining. So thank you. Um, I think we should get started. Good morning, everybody. Happy Wednesday. Two things I wanted to talk about today. The first one, and the most pressing item, is that the new condo laws are passed. So we did a video last week on this, and it was House Bill 913, supposed to go into effect July 1st, but we were waiting on Governor DeSantis to sign it. He took his sweet time, but he did sign it. So on Monday, it officially passed. It will be new law as of July 1st. And the big thing for real estate professionals to understand is that instead of that 3-day condo review period, it's now 7-day condo review period. It's a huge change, at least on the face of it. Now, if we really look at it, I think this is a good thing. I really do. And the main reason is because previously the condo review period was always counted in business days. So I'll give you an example. Let's say you go under contract on Friday. Friday would be day 0. And I've done videos on this, how to count. So if you need to watch how to count, that's a really good one. But your first day is always day 0. And then because it's business days, Saturday and Sunday do not count. So you still at 0. And then Monday would be day 1, Tuesday is day 2, and Wednesday is day 3. So in that case, it's kind of the equivalent of a 5-day time period. And that's, if there was a long weekend, let's say Monday was a holiday, now it's going to be 6 days. Now you can't count Monday either. So it'd be Tuesday, Wednesday, Thursday. Thursday would be the last day for the condo review period. So I think this is good. So now the 7-day, it's actually going to be calendar days, just like everything else in our contract. So now it's going to be, same example. Friday is day 0, Saturday, Sunday, Monday, Tuesday, Wednesday, Thursday, Friday. Friday would be your last day on that. So if you go under contract on Friday, Friday the next day would be your last day of that condo review period. So I think it's going to make counting and following these timelines a lot simpler. I really do. And I think that's the mindset you have to have, even if you're worried that it's not going to be simpler. I think you really just have to kind of take it with that mindset. Tim has raised his hand. Tim, if you want, feel free to chime in. Let me know what you're thinking. So that's the big change that we're going to see. Now, they further clarified that the day starts when the buyer gets all the documents. That was always the law. The law always specified that it wasn't when the real estate agent received those documents, it was when the actual buyer received the documents. So, that's things like the bylaws, FAQs, governance form. And so that actually didn't change in this House bill update. It just further clarified the requirement that it get to the buyer. Now, NABOR has a really neat form. It's that condo receipt document. You don't have to use it, but a lot of people like it because it gives them confirmation that the buyer has received it and when. We do see people play games with it a little bit. They might put the wrong dates, or they, I never even opened my email, so I didn't see it till Monday. I wouldn't overthink it. If you know that the buyer got everything on Friday, then you're going to be okay. If you got an email from the buyer's agent saying that, yes, I've sent everything to the buyer, that's good enough. It really is. It's kind of on them at that point. Tim, I don't know if you wanted to ask a question, but you just let me know. Let's see. All right, I'm back. All right, so that's kind of the big thing. Now, the other thing, and we did this last week, and it's the same, but just as a very quick summary, the other thing that changed was the Sears study. So that is the reserve study. And again, I've kind of been pretty outspoken on this. I think all the naming for these studies is wrong. It's just confusing. I call it a reserve study. That's all it is. It's reviewing the budget and the upcoming repairs or maintenance items to see, are we underfunded or overfunded? So this update, it fixed two things. and thanks, Tim, did two things. It extended the deadline for associations to next year for a lot of associations. So instead of December 31st, 2024, the new deadline is December 31st, 2025. So if you have an association that was out of compliance because they didn't have their reserve study yet, this will kind of delay their compliance issues for another year. Now, I would use that as a red flag personally. If the association, at this point, they were 6 months late on getting a reserve study, I think that's problematic. And I can't imagine what the issue is or what the reason would be other than, just poorly run association. I think that's got to be the reason. And I think that's a red flag, just as much as if the report was bad, not having a report, I think you got to think about it a little further. So it did delay that, but I'm sure some associations were lobbying for that, but I don't think it changes the math for many people. And then the other big thing that it changed was it changes how we count how many stories buildings are. So before it was 3 stories. It didn't matter, if the first floor was garage or not, but now it does. So if the first floor is non-livable space, say it's garages or maybe a lobby, elevator spaces. If it's anything like that, that first floor doesn't count when determining how tall a building is. So let's say there's a 3-story building, but the first floor is garages. Well, we don't count that then. So now we start, the next level is actually 1 and then 2. So that would be a 2-story building. And it's actually now it's not required to do any of these studies. It's not required to do the milestone, the reserve study, or the turnover. And so I think that is going to remove a lot of condos from this law. I don't know the number, but it'll be in the hundreds, I would guess. Um, and Vicky, yes, reserve studies are on condos. Now, there's been a lot to talk about these reserve studies. I think it's a good thing. I bought a house or a condo in Atlanta years ago, maybe a decade ago, and there was a reserve study, and I was able to look and see, are they collecting enough money to meet the upcoming repairs, the maintenance obligation? Are we underfunded? Are we overfunded? Are we properly funded? So associations across the country do reserve studies, and possibly HOAs do reserve studies as well. But most likely it's a condo. And in Florida now it's required if you are 3 stories or greater. So every 10 years, every 3-story condo is going to have to get a reserve study, no matter what. And then the milestone, that's once it hits 25 or 30 years old, if it's 3 stories or taller. And then the turnover is for brand new buildings. I actually really like the turnover study. I think it's a cool idea. And basically what it is the developer, they built the building, the subdivision, whatever it is, and before they turn over the association to the homeowners, because up until that point, the developer controlled the association. And now that they're pretty much sold out, they want to turn it back to the homeowners and they want to say goodbye. Before they do that, they have to do a turnover inspection, basically a very similar thing to a milestone or a reserve study. And then they have to provide financials and a lot of other documentation. So I think that's a wonderful thing, but it's pretty limited in scope. There aren't that many new condominiums that have been built the last couple of years, but any of those, they would be subject to that. Michelle, and Michelle mentions that NABOR just sent out the new documents via email. That's amazing. I actually was looking at their website before our video started, and I didn't see it just yet. So I'm wondering. So I think what they were changing the sales or let's see if the condo review period is what they had changed. The condo addendum is what they were wanting to change. And then there were a couple others. I'll share my screen and we'll look at this together. So it's the addendum to sales contract, condominium. That's the one that I want to see if they have fixed. So it's right here. My guess is that the one online has not yet been fixed. No, it's not. It still says 3 days. So the reason why I think it's probably not on the website just yet is that it's not effective until July 1st. So for the next week, you're still going to use the old forms, but then you're going to start seeing the new ones come out. So Michelle, thanks for pointing that out. That would have been cool if we could have looked at that. But really, it shouldn't change anything in the form other than the reference to a 7-day review period as opposed to the current 3-day. And instead of it saying business days, it'll say calendar days. So that's our update on the condo stuff. I really wouldn't worry too much about it. And then what I would think about, and I'm getting some feedback on this. I'm curious what people think, but what I would think about is this is the perfect opportunity to do an as-is sales contract. So currently, the majority of closings here in Naples, despite my objection, the majority of them are still standard sales contracts. It's what we call a repair contract. And the as is a smaller proportion of deals. But on condos, I think that should switch now because the standard contracts, they're confusing. It's hard to explain to a buyer and let alone a seller as well, what a defect is and what cosmetic is. If you're going to throw in the mold and radon, let's say you change, they've got the mold. There's a mold addendum that you can use now in NABOR. And that one basically says, any kind of mold would be considered a defective item. And then there's some agents that use addendums that say, an old water heater is a defective item, even if it's working, and things like that. I wouldn't do any of that. I really wouldn't. I just do a 7-day as-is inspection on any condo. Don't get into the weeds on whether it's defective or cosmetic. And if the buyer wants out, yeah, they're going to terminate. But guess what? They were going to terminate anyways. And I suppose, the next question, the evolution of that would be, well, what if I want to give them more than 7 days? What if they're asking for 12 days? What if they're asking for 15? Should we still use an as is? Um, that's going to be up to you. If it was me, I would push pretty hard for as is contracts because it makes my job easier. It really does. Terminations are hard enough when it's an as is contract. It's brutal on a seller and the agents get upset, I get upset. But when it's a standard and we're fighting over the deposit and whether something was defective or if the seller said yes, or did I make a mistake in how I did the form, that's a nightmare. So don't turn a bad day into a week-long nightmare. And the best thing I can suggest is to use an as-is contract. And people that have followed me for a while now know that I feel strongly about that. Not all of them do it, but I am seeing a lot of progress in that way, and always curious what people think. It's fun. It's a little different. I think there were a couple more questions. Oh, Michelle sent it to me. Oh, that was very nice of her. Oh, look at that. They did send it. All right, so that was kind of the main point. Let me see if I can share my screen. We'll look at my email here. So Nabor just sent out this Nabor condo/co-op form changes. And actually, I even forgot to mention the co-ops are going to be affected by this as well. So it's all going to be this new 7-day condominium and co-op document review period that replaces the old 3-day condo review period. Using an old NABOR form could result in a contract that is voidable by buyer prior to closing. Therefore, it is very important that you review and understand these changes. They have done a video. Sam did a wonderful video. So if you want to watch his video through NABOR, you're welcome to do that. And, it looks like they probably haven't. Oh, here are the forms. Look at that. Well, that's awesome. Let's see if I can share that form. All right, let me know if you're not looking at the new updated ones, but here it is. So really, it's going to look the same except for it says 7 days. That's really the only difference that you're going to see. The other thing on here is that the milestones and the reserve study, the turnover, that's all 7 days as well. So everything's been updated to a 7-day. It's a pretty major shift in how we've always handled this. I think it's fine. I don't think it's that big a deal. A lot of people, I had this question yesterday, what should I be selecting? 99.9% of the time, you're going to select B, where it says that it's voidable by buyer within 7 days. That's what you're going to select. In fact, that language is already added into here under the all the other documents. So that it's a little confusing, but the way they've done it is they've got two things going on. One is the traditional condo review documents, so bylaws, covenants, any amendments, financials, condo governance form. I'm sure I'm missing a bunch of them there. But I think there are like 6 reports or 6 forms that are under this first one, and that gives the buyer 7 days from the day that we go under contract. And the later of 7 days from when we go under contract or from when the buyer receives all the documents. All right, so that's already in the NABOR condo addendum. The FARBAR one, you have to check whether it's this, or the other one is when you can say that they've gotten it more than 7 days prior to going under contract. So I wouldn't kind of mess around with this. I would simply just always select B. The only time I would select A is if, let's say you were under contract earlier, fell apart, and then you went back under contract with that same buyer. It's possible you could do that. Rick, I did notice you're specifying in here, it says excluding Saturdays, Sundays, and legal holidays. I don't, that's extending it. Oh, look at that. Well, look at me. Well, now I can't upload this video because I've just been wrong for the last 20 minutes. It does say 7 days excluding Saturdays, Sundays, and legal holidays. Well, I have a little bit of egg on my face. Look at that. So, seems to be that it's still business days. I'm going to have to confirm that. I'll send out an email after this video just to confirm because it was my understanding that it was all calendar, but it looks like I might be wrong. So look at me. Maybe you should stop watching. Well, Rick, thanks for pointing that out. That really pops my bubble. I was kind of excited that it was just calendar days. Bummer. So Sigrid actually mentions, I've always had a problem with the major difference between as is and standard. And Sigrid, maybe you can kind of specify exactly what you're talking about. From my perspective, the difference between the two forms, and NABOR and FARBAR treat these two forms quite differently. But generally, an as-is contract, it still gives the buyer the right to do an inspection, and they can get out for any reason. Any reason. They can get out because they won't replace the water heater, or they won't give them a credit for the roof, or because they think they're overpaying, right? That it's what we call a free look. The buyer doesn't need an excuse. All they need to do is deliver termination. Whereas a standard contract, it significantly limits the reasons why a buyer could terminate. So on a standard contract, the buyer could only terminate if they, one, found a defective item, something that doesn't work. Let's say it's wood rot or a pool heater that doesn't work, or a refrigerator that has broken, or in air conditioning that's not blowing cold air. Any of those items are considered defective items. Any staining, anything that doesn't affect the usability of the item but might affect the cosmetic nature, that is not something the buyer could get out for. But it actually requires two things. They have to find a defect, let the seller know, and then the seller has to refuse to do it. Only then could a buyer terminate and get their deposit back. That would be terminating with cause. That would fit the definition, that very narrow definition of the contingency, the inspection contingency. So Sigrid asks, and a lot of buyers confuse this, wouldn't a buyer want a standard contract? Isn't this better for a buyer? No, because in both options within NABOR, within both options, standard and as is, the seller can say no. In both options, the seller can say no to a repair. The buyer could have a legitimate gripe. They could say the roof needs to be replaced or it needs to be repaired, and the seller can still say no. in either way. So it really doesn't change anything on the seller's side of it. They can always say no. So the only benefit to a buyer is that maybe the seller feels obligated to do these repairs. Maybe the seller's like, oh my gosh, well, it's a defective item, so I'm going to have to fix it. Otherwise, I'm going to have trouble selling this to someone else. It's really not how it works. Um, a buyer, selfishly, a buyer would want any reason to get out of the deal and get their money back, selfishly. They could, my dad always likes to tell a story of when my wife and I were buying a house and the railing was a little loose. And that was kind of freaking us out because we had young kids. I still have young kids. That was a problem. Was that a defective item? No, it actually wasn't. Not a defective item at all. Now, luckily, I had an as-is contract, and I was able to say, "Look, I want you to shore this up, make it a little stronger." And they're like, "Okay, yeah, that's fine." And I was fair. We negotiated in good faith, and we didn't ask for very much. And the seller said, "Fine." But one thing that was removed from that conversation was I never had to explain whether it was a defective item or not. We never even had that conversation. I think that's huge. I think it's massive because under most of my clients, most of your clients, you don't really know them. You're spending a little bit of time with them. You might spend a little time talking about the sales contract, but how much time are you really spending going over an inspection contingency? How much time do you spend discussing the difference between defective items and cosmetic? I would say generally almost zero. You're going to do maybe a 20-second elevator pitch on, all right, we make a small deposit, we'll do our inspection. If there are any defective items, we'll ask the seller to fix it. If they don't, you can get your money back. That wasn't even 20 seconds. That's really what most people say. And if you're from New Jersey, you're from New York, you're from California, Texas, you don't know what defective versus cosmetic is. You don't have any context. One of the worst case scenarios in my mind is mold because there's toxic and non-toxic. Well, toxic is a defective item. That's black mold, basically. It's a problem. It's a huge problem. Buyer would note that on their inspection. So if the seller refused, the buyer could terminate. But if you found a house with black mold, wouldn't you just want to terminate? Oh my, you would be freaking out. The buyer would be freaking out. I can't move forward. My wife is freaked out. I can't do this. We're leaving. If I put an offer on a house, did an inspection, and we found black mold, I would certainly be terminating. I don't care what the seller did to remedy it. I needed to get out of the deal. You can't, not in a standard. And that buyer, when they're put in that box, and you have to go to them and say, we can't just terminate. Your 10,000, your 20,000 is, hard until the seller refuses. Well, is the seller going to refuse? No, seller's not going to refuse. So who benefits in that scenario? The seller probably benefits because they could hold a buyer to the deal. They could hold a buyer's 10 grand, 20 grand in the deal in the, best case scenario, most likely. But who does the buyer turn on in that situation? Their realtor. They turn on you, I promise you. So maybe the seller benefits a little bit, but the buyer's angry and they get a bad taste in their mouth. They probably don't move forward. They probably don't close. They don't make that second deposit. So the seller doesn't get a deal. Maybe they get 10 grand out of it, but they're really not happy. I promise you, they're not happy. The listing agent's probably not making any money on that deal. Technically, a listing agent can recoup some of the deposit, but they're not going to do that. The seller has a huge mold problem. And the buyer's agent is made to look like the bad guy because they never explained the inspection contingency language. And I just did, 3 weeks worth of work. Brutal. I don't like standard contracts. I don't like them at all. So if you ask, doesn't the standard protect a buyer? No, it doesn't. It doesn't at all. Does it protect a seller? Maybe. Does it make a seller happy though? Does it force a closing? Not really. I think think about if you were selling a car and you let the buyer take the car over to the auto shop to have it looked at, you're not holding a non-refundable deposit usually. You're not, if they found a huge issue, are you going to hold their money and refuse to give it back to them? Probably no. You're just going to negotiate in good faith. Hey, I'll fix all those things. I'll reduce the price a little bit, whatever you want to do. I think that's good faith. I think there's a lot of value in operating in that way. Um, so Robert had a couple of questions. As is contract past termination. So can be terminated if property is not able to get a mortgage. So I suggest always saying that you're getting a mortgage and defect is still an out. Let me see if I understand that question. Had buyer's lawyer insist on attaching an inspection report to the contract. Mortgage companies said no. Um, so this past termination can be terminated if property. So you're past your as-is inspection period, but maybe you terminate because you can't get the mortgage. You have a financing contingency. So in that sense, is a defect still an out? So Robert, I think I understand your question. In FHA and VA loans, there is an inspection appraisal. So appraisals for those kinds of loans are a lot more significant. They have an extra safety piece to it. So I'll give you some examples. The most common example is you have a front porch with no railing. And so the FHA and the VA appraiser will come to the house, they'll do an appraisal on the value of the property, and then they'll notice that safety hazard, that there's no railing around the porch, or there's no railing going up the stairs, or any number of reasons. It possibly could be that the well is too close to the house, things, or the septic system is too close to the well, something like that. And that is not something you would see on a typical appraisal. You would not see that on conventional loan or a commercial loan. You would see it on a FHA or VA. So they could point out something like that, which is maybe a defect. Maybe it's not. It's some version of a defect. And the buyer possibly could get out of the deal if the seller refused or if the amount of the money, amount of the repair was too high. You could see that on a roof if there was a major roof issue. The lender may not allow you to close on that. They might refuse, it could be an appraisal issue. I wouldn't rely on that. I think that's very dangerous to rely on because lenders are unpredictable. And it's not a sure thing. And only if the lender denies the buyer or if the appraisal comes in much lower could a buyer get their money back. I think that's pretty risky. You don't have a whole lot of control. And so, and to that point, financial contingencies, if you explore that issue of, you want to waive the financial contingency if you're a seller. And the buyer, they're nervous about waiving the contingency. Well, the real risk to a buyer or to a seller, I suppose, the real risk after the appraisal contingency or after the finance contingency and before closing is if the buyer loses their job. That's the risk. Because right up until that contingency, you've gotten your approvals, you've got your appraisal, people have looked, the lender has looked at your financials. But if you lose your job the day before closing, then yeah, that's a reason not to get your loan. If there are things of that nature. If you lose the ability to get insurance, let's say there's a hurricane that comes through, or there's an issue at the house, and all of a sudden your insurance isn't allowable, you could get your money back. You could get denied for the loan because it's not insurable. I think the insurance is probably a bigger thing with financing contingencies, but I wouldn't rely on the financing contingency for defects. Robert, that's a great point. I don't think I've ever gotten into detail on that. So Vicky asks, isn't it also true that any defects discovered must be disclosed? Vicky, I'm so glad you asked this question. A new seller's disclosure should be filled out if the property goes back on the market. Correct. What does an agent do if the seller is unwilling to walk away from that listing? Question mark. All right, this is a wonderful topic and it gets confused all the time. So Johnson v. Davis was a case back in 1985. It was over in Miami. And in that case, in that scenario, and I'm going to mess up the exact happenings of it, but it built the foundation of the seller disclosure laws here in Florida. It's the standard. That's where it all started. And in that scenario, what happened was the buyer came, they put money down on this house, and they asked questions about the roof. They said, "Hey, have you had any trouble with the roof? It hasn't been raining now, but I know it was raining last year or earlier this year. Have you had any problems?" And the seller said, "No, nope, no problems." Oh, the camera fell. Man, today's videos are just. All right. So they asked the seller about the roof, and the seller says, "Nope, no problems." Well, they find out later that my camera doesn't work. That's weird. There we go. That won't happen again. Find out later that the seller was lying to them and that the roof had been flooding every time it rained. Now, the interesting point in that story is that the buyer relied on the seller's disclosure that there were no problems. The seller didn't say, "Oh, I don't know. Haven't heard of anything. I'm not aware. I just bought it a week ago." That wasn't the case. They knew, they lied to the buyer, and then the buyer relied on that information. That's a very important distinction. They asked, the seller lied, and the buyer relied on that information, and it ended up being, a huge roof problem. So from that case, the judge determined that the seller has no duty to disclose unless it is a hidden or latent defect, something the buyer could not have discovered on their own. And then separately, there's other tort law that says if a seller lies and the buyer to a material fact, they misrepresent a material fact, and the buyer relies on that information to their detriment, the seller would be liable for that. So you have two things. If it's hidden or latent, and the buyer has no way of knowing it on their own, and it's a material fact, or if the seller lies about whether something is a problem or not, then there's a problem there as well. Anything in between that, anything outside of that definition would not be a seller disclosure requirement. So Vicky, to your question, not everything has to be disclosed. It sounds silly, sounds counterproductive or counterintuitive. But let's say the first inspection had a leaky water heater and it was obvious, or I don't know, a broken window, and the buyer has every opportunity to inspect the property and just misses it. Is the seller obligated to share that information? Technically, no. Most of the cases, no. Now, could this be, something you sue over? Probably. But based on the current case law, you don't have to disclose everything. You don't. You just have to disclose the things that a buyer could not have determined on their own, and you cannot lie to a buyer when they ask a direct question. Another example of that is you have no obligation to disclose if someone has passed away in the house. But if a buyer asks you and you lie, that's a problem. And so lying is a problem, just like, when we were growing up. Be very careful about that. If a buyer asks you, "Hey, why did that other deal fall apart?" and you lie about it, major problem. Now, to the second part on Vicky's question, what's an agent supposed to do? So an agent has a certain duty to the public. If the seller is lying, they have a duty to correct that lie. They have a duty. So usually the way I present it is I say, let's say a seller's being difficult, they refuse to disclose something, and it's a really big thing. It's a hidden or latent defect. It's something a buyer could not have determined on their own. If that's the case and the seller refuses, the way I go back to the seller and I say, "If you don't disclose it, I will." Really that simple. I am obligated to. I've talked with my broker, I've talked with the attorney. I have an obligation under my license through Florida law to disclose it. So if you don't do it, I will, and it will look really bad. So we might as well do it together. Let's fill out this, let's update the seller disclosure, or let's fix this. Francesca has a question. Let's see if I can get her to unmute. Go ahead, Francesca. Feel free to unmute yourself. Francesca, are you there? No, maybe not. Okay, no worries. Um, so if you need to walk away from that listing, I would support that. I really would. In that scenario, you've got a seller who's just being destructive and he's going to get you sued. Yeah, that's really brutal. I wouldn't be afraid to walk away from a listing. And Vicky, you're an incredible agent. I know you would know the right thing to do. But a lot of times we don't have the luxury of walking away. You know, we need that listing. This is our career. We put a lot of effort into it. So usually what I do is I just say, I go back to the seller and I just put them on the spot and say, if you don't do it, I will. And I'm going to have a totally separate email that I'm going to disclose to everybody, or some sort of MLS attachment. So hopefully that's helpful. It's a weird, crazy market. There's so many rules. And so if you see an opportunity to simplify all of these sales contracts and simplify how you present properties and how you market them, and ultimately how you get it sold, I think you should explore that. You know, if it truly is 7 business days, let's do that example. So you go under contract on Friday, Saturday and Sunday don't count. So then Monday, Tuesday, Wednesday, Thursday, Friday, again, Saturday and Sunday don't count. And then Monday, Tuesday. So Friday to Tuesday. So let's look at how many days that really is. So if we went under contract this week, June 27th, that's June 27th, a Friday. Saturday, Sunday don't count. Oh gosh, it's 4th of July next week, isn't it? So 30th, first, so 30th first, second, third. So that's 4 days. And then the 4th is a federal holiday, so that doesn't count. The 5th is a Saturday, the 6th is a Sunday, so those don't count. Then you've got the 7th, the 8th, and the 9th. So we go under contract June 27th. The buyer has until July 9th to terminate the contract. That's a lot of days. And so I'm going to have to double check the House bill, and we'll have to see what that final statute is. But in that case, you're at 7, 8, 9, 10 days. That's a 10-day condo review period when you count calendar days. That would be a 10-day calendar review period. Now, if that 10th day, if that 7th day ends on a weekend or something, you can't count those days, obviously. So on a 10-day condo review period, just use an as-is contract. Just please, for your own sake. And for buyers, if the buyer questions, oh, I don't want an as-is contract, I would be like, well, you just don't know. You don't know what you're thinking. The as-is contract gives the buyer more ability to terminate, but realistically, it gives the buyer and seller the opportunity to negotiate in good faith. So if the buyer finds out that there's $50,000 worth of repairs, the seller's not worried about what's defective and what's cosmetic, and really the buyer isn't either. They're just negotiating like they did on the sales price. You know, the sales price and negotiating inspections, one shouldn't be significantly harder than the other. At least that's the hope. So that's a lot. That's a lot. Teresa says, can the buyer waive days if they review the docs and are good? No, no. There are really two options in the statute. I think if you receive the documents 7 days prior to going under contract, now it seems that that's going to be not including weekends or holidays. So in that case, you'd be 10 days before going under contract, you got everything. And then we'd have to change the condo addendum. So it's no, the buyer really can't waive it. There's no way to waive a constitutional right. If they have everything, they have everything. And then the dates just start going. So I think you're just going to have 10-day or 7-day inspection periods. There's no other way to do it, especially with condos. And you'll learn, you'll see if that, if you want to do the same with a single family. Just to kind of finalize this whole idea, the standard NABOR contract is 13 pages long. The as-is NABOR contract is 11 pages long. Take the opportunity to have a smaller contract. Really, it's much better. But you can't waive days. It's always going to be 7 days after you go under contract. All right, Krista has a question. To cover ourselves, do we have to get an email from the buyer's agent stating that they have received it, or the condo doc receipt form back? What if they're not responding, will not provide timely, so they are stalling? Do we have any recourse? You have no recourse. And so I wouldn't overthink it, right? Ask for the buyer to sign the condo doc receipt. I would say majority of agents will have their buyer sign that. And so most of the time, you're not going to have a problem. And then for those who aren't filling out that, there's another big portion of agents that'll just send you an email saying, yes, they've gotten everything, or I forward your email to the buyer. That's great. So we're really looking at maybe five, and you might feel differently. I'm thinking 5 or 10% of the total population just stall and refuse to give any feedback. So there's nothing you can do. I mean, you could try and get them to confirm that before you go under contract. You could make the condo doc receipt a condition of accepting the buyer's offer. I think that works. But if you don't do that and you find yourself a couple days in and they're just stalling and refusing to talk to you, don't worry. Really, you know that you sent everything. You know you've asked for confirmation. And if the buyer later tries to get out of the deal under the condo review period, there's going to be a lawsuit and there's going to be a discovery. And you can potentially, claim, you could go to the NABOR or BAR or Marco Island Board of Realtors and maybe even have them investigate, the consequences or the result of what happened, and there's discovery. So if those were shared, it's going to be discoverable. If they weren't shared, that's going to be possibly some sort of ethics dispute within your association. So not much you can do unless you do it ahead of time. Make it a part of your, a condition of accepting the buyer's offer. Hey, I want you to first confirm that you've received everything. Then I'll have my seller sign it or review your offer. I think that could work really well. All right, so Tim says, some listings will state no as-is contracts. How should that be handled? It's a great question. You can do it one of two ways. One, you do it anyways. The listing agent is obligated to share every offer. Now, you might get countered with a standard, or they might say, hey, we're not doing that. We already told you. And so in that case, worst case, you wasted your time and you might have to then go and do a standard. I would say just talk to your buyer about the issue and say, look, I prefer the as is, or my attorney provides the as is. Which one would you want to do? Because the seller wants the other one. If they're like, oh, well, whatever. I think you just have to get your buyer's buy-in. You go back to your buyer and say, what would you like me to do? I can see it either way, Tim. I really could. I always say this about people who want to use me. So there's some agents who in the listing will say, seller requires that you use Ross title. You don't have to do that. I can't be in front of the seller's best interest. I'm not going to put myself there. I'm not going to put myself in front of the buyer's best interest. The most important thing is that you get the deal under contract. So I always have a motto of like, get it under contract, protect your client, and get it closed. You need some combination of all three of those. And if pushing me or pushing a certain kind of contract gets in the way of that, that doesn't work. You can't really do that. Now, if you want to say, we prefer an as is, or we prefer a standard, or we prefer NABOR, or, bring all offers, though seller prefers a NABOR sales contract. I think that's cool. Bring all offers, seller prefers, seller will use Ross title or whatever it may be. I think you could do it that way, but trying to really push things and not prioritizing the buyer or the seller's best interest, it gets tricky. That gets very tricky. Mike says, hey, Mike, how do you feel if only one of the married sellers signs the seller disclosure statement? Where does that leave the buyer? I'm okay with it. I'm okay with it. You could ask, hey, why did the wife not sign, or why did the husband not sign it? You could ask, but ultimately, the seller disclosure is meant to protect the seller. That's not what most people think. Most people think this is for the buyer's benefit, and it can be, but the primary goal is to protect the seller. So anything you put on there, the buyer can't sue you for later. Anything a seller puts on the seller disclosure, the buyer can't claim not to have known about it later and sue the seller, claim some sort of ethics dispute or whatever. So the seller disclosure really protects the seller first and foremost. So we've seen, and Mike and I have talked about this, that a lot of the higher end homes, the listing agents are putting these weird disclaimers in MLS saying, no seller disclosure provided, buyer beware, or whatever. And if you question them, they'll say, oh, my attorney tells me not to do a seller disclosure. That's bogus. That is bogus because the seller disclosure protects the seller. If the roof was replaced last year, tell them. If there was no permit for the bathroom renovation, tell them. If any of those things are a problem, if you're worried, I had a call yesterday. There was an issue with the dock at this seller's house, and he has three different engineering reports, and he's got a 15-year warranty, but there was a lawsuit, and there was all these problems. He says, Christian, what do I do? And I said, we're just going to give the buyer all of it. We're going to have you fill out the disclosure. We're going to say see attached, and we're going to give the buyer each one of those engineering reports. And we're going to let the buyer do their due diligence because if we held back one of those reports, if we only gave two of them and we held back the third, seller's going to get sued. It's really that simple. Um, Krista says, oh, no, that was the one we already talked about. All right, Michelle says, here's what she found. Calendar days in Florida real estate contracts, unless business days are explicitly stated, days, generally referring to calendar days, which include weekends and public holidays. However, the new 7-day rescission period for non-developer sales specifically excludes weekends and holidays. Yeah, and Michelle, that's what it always was with the 3-day. So with 3-day, we never counted the weekends or holidays. And it looks like the 7 day is doing the same. That's a big deal. That's a big change. That's going to make these contracts, the inspection period pretty lengthy. I would think a buyer can do all their due diligence in that time period. They can review documents, they can review it with their attorney, they can go over the milestone reports and the reserve study, they can have an inspector, they can do everything in that time period. And that's mentally, we just have to be okay with it. Just this that we have to look at the positives and and really just kind of push forward. Michelle says, so did NABOR legal resources have the option regarding calendar days to be structured with weekends and holidays or without? With the condo review period, Michelle, NABOR didn't have a choice. They just have to follow the statute. But with everything else in NABOR, it's always been calendar days. Kathy asked, what happens when a seller will not fill out a seller disclosure? If you don't fill out a seller disclosure, I think Downing Fry, where Kathy is licensed, they have this waiver, or it's really just a disclaimer saying, you understand that, seller disclosures are good for the seller and they should be filled out, but you've decided not to. You're indemnifying us in the event that there's anything that needed to be disclosed and that you failed to do so, something of that nature. I think that really just having a pretty standard response of like, all my sellers fill out seller disclosures because it protects them. What seller would be silly? Now, I'll give you another scenario. Sometimes some of my clients, they inherit the property and they claim that they don't know anything about it. Well, let's prove it. That's what I tell them. Prove it to me. We sit down with the seller disclosure and we try and answer every question. If the seller legitimately answers, I don't know, for every single question, that's the same as not doing a seller disclosure. But there's a lot on there, like when was it built? Who's the property manager? Have you made an insurance claim? When was the roof installed? How old is the water heater? The seller can find that information out. Just go find it out. let's look online. Let's see when the roof was installed. Let's see, let's look at the water heater and see when the manufacturer date is. I want the seller to try. If they really, if it's, I don't know, I don't know, I don't know, I don't know, have them do that. But, maybe you don't share it with the buyer, but these states and the trust, they tend to be the most difficult. If anyone's willing to fill it out, that's who I have fill it out. Sigrid asks, oh, let's see. Sigrid says, can we change the time frame from 7 to 5 days under other terms and conditions? No, you cannot. This is a constitutional law for Florida. So this is the buyer's constitutional right to do their condo review period. They can't limit that in any way. Yeah, Kim mentions that landlords say, I don't know, and they refuse to do seller disclosures. It is BS. You know, they're just not being honest. And it's going to come back on them, and it's going to make doing our job harder. I think real estate agents are really good salespeople, right? So give us all the information, and we'll modify it, we'll edit, we'll spin it in a way that we can disclose while selling. That's our job. Our job is to put the property in the best light possible without breaking any laws or failing the consumer. Vicky says, if you're the selling agent and there's no seller disclosure, is there anything we should do? No, not really. I mean, I would ask if there's one available. And if the answer is no, I would keep a copy of that email and have record of that. And then I would just let the buyer know, I'm being told there's no seller disclosure. Please be extra careful. Let's get every inspection. Let's ask lots of questions, because we're not being given anything. And honestly, if I wasn't given a seller disclosure, I want an as-is contract. So that's the cost. If the seller's going to be difficult and not do a seller disclosure, then I want an as-is because I don't know when the roof was installed. I don't know how old the water heaters are. I don't know about permits. And to that point, I would put in every one of your offers, I don't care what contract you're using, seller shall close all open or expired permits. Just put it in every offer. In fact, all the brokers that are listening, Mike, you're on there. Make it automatic in every sales contract. In other terms and conditions, seller shall close all permits, open or expired. Just put it in there. It needs to be, the alternative is you do an amendment after you find out and the seller agrees or doesn't agree to close it out. But I think that's a wonderful tool, and you should put it in every offer, every single offer. And if the seller refuses and they're like, oh no, we don't like that, and they want to cross it out, now I got some questions I need to ask. All right, call Ross Title, have them do a permit search. Let's find out what we're getting ourselves into before we go under contract. All right, so Carolyn says, isn't that in the as-is contract? I think she's mentioning permits. So permits are not mentioned in as-is contract anywhere, other than there's some sort of disclaimer that the seller's not aware of any open permits or insurance issues. But in both standard and as is, it's an inspection issue. It's not a title issue. Permits are not a title issue. I could close a deal and give the buyer clear title even if there are 100 open permits. I just could. I don't want to. That's no fun for the buyer. But if you just put it in the sales contract, even though it's a defective item under a standard NABOR, why do I even have to ask? I just want it in the original offer. Seller shall. It doesn't hurt you. It only helps. I think it potentially avoids an issue if you miss it. If the law office or the title company misses it initially and then we find out about it later, having it in your contract automatically protects you. It makes you look like a superstar. So that's really what I would do. I think it would be amazing if more and more people did that. It'd be even better if permits didn't exist. That'd be better, but that's okay. Beggars can't be choosers. All right, so I meant to talk about some title issues that we're seeing, some scams. We see rental scams, we see wire fraud scams, and there's some pretty weird ones. What I'm going to do is I'll do it in an email, so you'll see that instead. But here's the thing. Scams are prevalent. I had one yesterday where there was a listing, and we found out 2 weeks later that the listing, the seller was a fraud. And so that's still happening. And what I suggest in that regard is for real estate agents, have them sign a listing agreement or buyer broker agreement electronically, and then check where their IP address is located. Because if it says Malaysia and you're supposed to be talking to someone in New Jersey, that's a fraud. Separately, use Forewarn. That's the app on MLS that all agents have access to. Use it. So if you have a number and you have a name, push it through Forewarn. And if they don't add up to what you're being told, that's a fraud. And if the two don't add up, if one says, the person's in California and the other one says, this person should be in, I don't, New Jersey again, you start asking more questions. And a lot of the great brokers, the law firms here in town, they're sending these vacant lot fraud letters. So just be very careful. We're all victims when something like that happens. So Caroline asked, how do you check the IP address? So when you do DocuSign or app files or something like that, the last page is what they call an authentication page. And it has all the details of when and how that person signed your document, and it has the IP address right on it. So DocuSign has the IP address for that person right there. It'll have the IP address for you as well. And you just copy it, you paste it into Google, and you see where it's located. So yesterday, when we did this, the IP address was a hidden address. It was through what they call a VPN. And so you can't determine where the person is, but it starts to think, you start thinking, all right, maybe I need to look a little further into this. Whereas if it showed New Jersey and the right person in the right town, and it's like, all right, this is all adding up, and you send a letter and you send it through Forewarn, I think you're pretty good. You're doing much better. I still prefer that you meet with the person, but I think you might be okay. Um, I don't know how you can find the IP address of an email. That's a little bit above my pay grade. That's a great question, though. That'd be really cool. I know that a lot of the brokers have IP or IT specialists. You might want to lean into that, or you could do a search online to see if that's a possibility. But I think you'd have to have access to like your back office or back administration within your email domain to be able to figure some of that stuff out. So I think you can tell we spend a lot of time and money on technology, and I think everyone needs to. We all have a business that we're trying to run and protect. So just spend accordingly. Don't be afraid to have extra security and to use your broker's security if possible. So that was wonderful. I'm so glad that this was helpful to you guys. You've been amazing. Rick, I'm going to yell at you later for correcting me. That was a brutal realization. So 7-day business, yikes. But I'll send a follow-up email so that you can see everything. And thank you, everybody. I hope that you have a good summer and that if you need me, just give me a call. Bye.